clients. Attorney and former police officer Marc Harrold is here to talk about the significance of this ruling. Marc, thanks for being with us.
Hey, thank you for having me on.
Where were you a police officer, by the way?
City of Atlanta.
City of Atlanta. Okay, well, we're swapping seats. I was in D.C. Now I'm down here in Atlanta. So.
Absolutely, yeah. I've read your bio. I knew that. But, yeah, we're swapping seats. You're down south now.
Exactly, Marc. So what do you think of the decision so far that Judge Perry has made?
Well, I think, this motions practice is a huge part of this. And you have to remember, if you ask somebody, they say, a trial is a search for the truth. Really, it's about admissible facts. And when you get into these things, what you have to look at, there's two big things to these motions. One is whether the person is just using their pure opinion about what the evidence showed, what the test discovered, what the test revealed. The other part of it is you're actually looking and arguing about whether the test itself is valid. So these are very complex motions. I think the judge is doing, I think his rulings have been pretty sound. I've read them. They seem pretty sound. He's getting a lot of stuff thrown at him early. There's a lot of motions. There's a lot of motions to reconsider. But, you always think about what the jury sees. A lot of times you forget there is a lot of stuff that goes on before a trial that can really impact the outcome of the trial, and we get to see it and read it, and maybe the jurors don't. And actually, they're not supposed to know about it. So motions practice is huge.
But I think it's good that Judge Perry, though, is taking some of these decisions, and he says, okay, as long as you can lay the proper foundation, I'm going to go ahead and allow them in. And he's basically allowing them in to let them argue and let the jury decide, what kind of weight to give these particular pieces of evidence.
Yeah, absolutely. The judge is looking at the legal admissibility. He's looking at the test. He's looking about whether something's more, as they say, prejudicial than probative. But it's the trier of fact. It's the jury. If it's a jury trial, the trier of fact gets to evaluate not only the evidence that's admitted, but also look at the witness, their demeanor, how professional they are, and make their own evaluations. This kind of thing, after it gets by, if the judge makes the right decisions on admissibility, it's really up to the jury, and it should be.
And, he's making some really precedent-setting decisions here, too, because never in the state of Florida have they ever had during a trial like this the admissibility of evidence of dealing with a canine search for and a canine discovering decomposition, if you will, a canine who's trained to smell for, I guess, gases or scent evidence, if you will, because of the dog, of human decomposition, and also the root banding of that piece of hair that was found in the trunk.
Yeah, this is really ticky evidence. It's really in-depth stuff. With the dog, of course, it's going to be somebody, it's a human being interpreting what the dog did, what did they hit on. Obviously, the dog can't testify. So you're looking at some very in-depth evidence that the jury's going to get to look at. And if these things are admissible, and it looks like the judge is going to find a lot of them that they are, the jury, I think this is going to be a long deliberation if a lot of this scientific evidence gets through. This is tough stuff even for the experts. And a lay jury looking at this stuff, I think they're going to have to take their time.
Well, Judge Perry is going to start selecting a jury, Marc, a week from Monday. And he says, well, he thinks he can do it in 4 or 5 days. Everyone we've spoke to, Judge Alex Ferrara yesterday, who's a judge down in Florida, they're saying, no way, no how is he going to be able to impanel a jury in that short a time.
Yeah, the judge is more of an expert in Florida law, but I can say that seems very, very optimistic. 4 days. I think it's going to take a lot longer than that, and it's important. In a case like this, the jury is huge, and in every case, but in this case especially, I think the jury is going to have a lot to do with the outcome. There's a lot of evidence here, but yeah, absolutely, 4 days seems very optimistic.
And especially in this, just in the guilt phase, and then going into the death penalty phase, it could be a long trial. But they were saying that they can get it done in about 3 months. Marc Harrold joining us from Washington, D.C. Thanks so much for your insight. Good talking to you.
Thanks for having me on. I appreciate it.
Thank you now.